Navigating the Labyrinth, SBA's Ostensible Subcontractor Rule. The world of government contracting offers lucrative opportunities for small businesses. However, it also presents a complex web of regulations. One such regulation, the Small Business Administration's SBA Ostensible Subcontractor Rule, often trips up unsuspecting contractors. This rule, codified in 13 CFR 121.103, aims to prevent larger companies from disguising themselves as small businesses by using subcontractors to perform the primary and vital work of a government contract. Understanding the nuances of this rule is critical for small businesses seeking to compete fairly and avoid costly legal battles. We will examine the legal implications, common pitfalls, and practical strategies for compliance. By understanding the SBA's Ostensible Subcontractor Rule, small businesses can confidently pursue government contracts while minimizing their risk. Watson & Associates, your guide in government contracting. Navigating the intricate world of government contracting can be daunting. That's where Watson & Associates comes in. We are a team of seasoned government contract attorneys dedicated to helping small businesses across the U.S. thrive in this competitive arena. We understand the challenges small businesses face. Our team provides expert guidance and unwavering support to help you secure and fulfill government contracts successfully. We work closely with our clients to ensure they understand and comply with all applicable regulations, including the often misunderstood Ostensible Subcontractor Rule. Whether you're a seasoned government contractor or just starting, Watson & Associates is here to help you every step of the way. With our deep understanding of government contracting law and our commitment to our clients' success, we are your trusted partner in navigating this complex landscape. Size matters. Common pitfalls for small businesses. In the realm of government contracting, size truly matters. The Small Business Administration, SBA, sets specific size standards to determine eligibility for set-aside contracts. These contracts are exclusively reserved for small businesses. The goal is to level the playing field and provide opportunities for small businesses to compete. However, the process of proving a company's size and eligibility can be surprisingly complicated. One of the most common pitfalls small businesses face is the miscalculation of their size. The SBA uses various metrics to determine a company's size. These include the average number of employees, annual revenue, or a combination of factors. Accurately calculating these metrics and ensuring they align with the SBA's definition of a small business is crucial. Even slight miscalculations can lead to disqualification from set-aside contracts and potential legal challenges. Small businesses must maintain these records meticulously and be prepared to submit them promptly upon request. The Ostensible Subcontractor Rule, a closer look. The SBA's Ostensible Subcontractor Rule plays a crucial role in ensuring the integrity of the small business contracting program. This rule prevents larger companies from circumventing size regulations by using small businesses as a front, while retaining control over the primary and vital work of a contract. In essence, the rule seeks to determine which company is truly performing the contract. They look beyond the contractual arrangement to examine the actual work being done. The rule comes into play when a small business, the prime contractor, subcontracts a significant portion of the work to a larger company. In addition to the limitations on subcontracting regulations, if the SBA determines that the subcontractor is performing the lion's share and primary and vital parts of the project, or if the prime is unusually reliant on the subcontractor to perform, it may consider the arrangement a violation of the Ostensible Subcontractor Rule. Understanding these factors is essential for small businesses to ensure their subcontracting arrangements comply with the Ostensible Subcontractor Rule. The SBA is vested with significant discretion in interpreting and enforcing the Ostensible Subcontractor Rule. While this discretion allows the SBA to consider the specific circumstances of each case, it also introduces a degree of uncertainty for small businesses. What may seem like a legitimate subcontracting arrangement to a small business could be viewed differently by the SBA. This highlights the importance of seeking expert legal counsel to navigate these complexities. On the one hand, the SBA's discretion enables it to make nuanced decisions. They can consider factors beyond the strict letter of the law. This flexibility can be beneficial in situations where a rigid application of the rule would lead to an unfair or unintended outcome. On the other hand, the SBA's broad discretion can lead to inconsistencies in decision-making. While the SBA plays a vital role in promoting small businesses, it is not infallible. Like any government agency, the SBA is susceptible to making mistakes, and occasionally these mistakes can result in unlawful agency decisions. These decisions can have significant consequences for small businesses, potentially leading to the loss of contracts, financial hardship, and reputational damage. It is crucial for small businesses to be aware of their rights and to challenge unlawful agency decisions. One common example of an unlawful agency decision is when the SBA misapplies the Ostensible Subcontractor Rule. This could occur if the SBA fails to properly consider all relevant factors, such as the Dover staffing factors, when evaluating a subcontracting arrangement. In such cases, small businesses have the right to appeal the SBA's decision. Small businesses should be aware of these procedures and hold the SBA accountable for following them. The Dover staffing factors are central to the Ostensible Subcontractor Rule. These factors, from U.S. v. Dover Staffing, 2005, help the SBA determine if a subcontractor is doing the primary work. Small businesses must understand these factors to comply with the rule. The SBA considers each factor holistically. The first factor looks at the complexity and importance of the subcontracted work. Specialized skills or equipment by the subcontractor indicate significant work. The SBA also reviews the contract value percentage for subcontracted work. A high percentage could very well show reliance on the subcontractor. Active management by the prime contractor supports their role fulfillment. Let's illustrate the Ostensible Subcontractor Rule with a real-world example. A small business wins a contract to provide IT services to a government agency, but subcontracts most of the work to a large IT firm. The SBA might determine the large firm is performing the primary work. Another example is a small construction company subcontracting specialized tasks but managing the project. The SBA is less likely to find a violation in this case. Understanding the SBA's perspective helps avoid common pitfalls. Complying with the Ostensible Subcontractor Rule doesn't have to be an overwhelming task. By adopting proactive measures and seeking expert guidance, small businesses can confidently navigate this aspect of government contracting. Here are some practical tips to keep in mind. First and foremost, carefully review all potential subcontracting arrangements to ensure they align with the SBA's requirements. Assess the scope of work to be subcontracted, the subcontractor's size and capabilities, and the level of control the prime contractor will maintain. Document the decision-making process and the rationale behind choosing a particular subcontractor. This documentation can be invaluable if the SBA later scrutinizes the arrangement. Regularly monitor the subcontractor's performance to ensure they adhere to the agreed-upon terms and that the prime contractor retains control over the primary and vital aspects of the work. Navigating the complexities of the Ostensible Subcontractor Rule can be challenging, even for experienced government contractors. Seeking legal counsel from attorneys specializing in government contract law is not just a prudent step, but an essential one. Experienced attorneys can provide invaluable guidance throughout the process, from reviewing subcontracting arrangements to representing your interests in the event of a size protest or SBA inquiry. Attorneys specializing in this area possess in-depth knowledge of the SBA's regulations, including the nuances of the Ostensible Subcontractor Rule. They can analyze your specific situation, identify potential red flags, and provide practical advice on structuring subcontracting arrangements that comply with the rule. Their expertise can help you avoid costly mistakes and ensure that your business operates within the bounds of the law. Having experienced legal counsel by your side can make a significant difference in protecting your business's interests and achieving a favorable outcome. The SBA's Ostensible Subcontractor Rule stands as a critical safeguard in the government contracting landscape. It ensures that legitimate small businesses benefit from set-aside contracts. While the rule's complexities can seem daunting, understanding its purpose and practical implications is achievable. By approaching subcontracting arrangements strategically, seeking expert legal guidance and prioritizing compliance, small businesses can confidently navigate this aspect of government contracting. By staying informed about the Ostensible Subcontractor Rule, its interpretations, and its real-world applications, small businesses can proactively mitigate risks and focus on what they do best, delivering exceptional services and products to the government. The SBA attorneys at Watson & Associates LLC help government contractors across the country to file and defend SBA-size protests. For immediate help, call 1-866-601-5518, seek expert advice, build strong relationships with your subcontractors, and prioritize transparency in all your dealings.